This is William and Lonsdale, a podcast about the legal ecosystem and the fascinating people who make it tick. Today, your host Michael Green speaks with barrister Debra Coombs. Debra's life in the law has seen her work in the private sector, the public sector, and as a barrister in two separate stints. She has worked for the Department of Labour, for the State Electricity Commission of Victoria, and for Corrections Victoria, and is now back at the bar working in the very interesting and relevant area of elder law. Debra has enjoyed these different roles and industries for different reasons, but one thing is for sure, her work has been interesting, varied, and sometimes quite surprising.
I appeared in the Magistrates' Court on a workers' compensation claim where I said to the plaintiff that I didn't understand how he had the work incident and I didn't understand his work history. And so I said to him, because I haven't understood it, I've adjourned the case so that your solicitors can get some more information and work the case up. I didn't receive another brief regarding that fella, and when I got to my later job at Corrections, I discovered the reason I didn't understand his work history was because he was a gangland contract killer and he didn't have a work history because he was in prison quite a lot, and the solicitors had discovered more about him and got rid of him as a client.
Our guest this morning in Lives in Law is Debra Coombs. Good morning, Debra.
Good morning, Michael.
Debra, you've had a varied career, different than a lot of people because you've gone in and out of private practice, working for the government and being a barrister. So as a starting point, can you just give us a brief rundown of where you've worked?
So I started off doing articles with Doyle and Kerr with my principal, Michael Dolan, who is now well known as the ethics expert at the Law Institute. And that was for 4 years. Then I went to Hall and Wilcox. So I went from a plaintiff to a defendant. And from there I went to the State Electricity Commission as a litigation solicitor, where it was similar to Hall and Wilcox in the sense that it's defendant's work, but it was still very different simply because dealing with an organisation rather than an insurance client most of the time. After that, I took a job as the solicitor to the Department of Labour, and that was very much a public service position where I had to be conscious of public service controls. Then I went to the bar, and there I primarily did personal injuries, which I had done throughout my career at that stage, not so much in the Department of Labour. And it was only one day, well, it was 1 week when I didn't have any briefs that week, and there were still job ads in the Age in the front, and I decided that it was 7.5 years. I hadn't applied for a job, and I should just see what applying for a job was like in the current climate. That was when I was offered a couple of the positions that I'd applied for, and I then took the position as the principal litigation solicitor at Corrections Victoria in the Department of Justice. That is not about doing criminal law per se, but dealing with prisoners, their personal injuries complaints, their administrative law complaints, and other issues that arise in any organisation. Our legal division was moved to the Victorian Government Solicitor's Office, but I still continued to do solely Corrections Victoria work. And when they were offering retirement packages in 2022, I took it and then decided that I wasn't ready yet to retire and I could enjoy myself much more by coming back to the bar, which I did.
Okay, so you're again at the bar for the foreseeable future.
Yes.
Let's go back to the start. It's always the best place to start. You grew up in Bayside, Melbourne with your mum and dad.
Yes.
And your older sister. Interestingly, your mum studied law at Melbourne University in the mid to late 1940s.
Yes.
Which was not common at that time.
It certainly wasn't. There were only 15 students in my mother's first year of law when she started in 1945.
Because it was the Second World War and a lot of younger people were in the services.
Certainly, and also because I know the subjects were 7 guineas a term, where most people were only earning a couple of pounds a week, the average wage.
I think for our listening audience, Debra, you better explain guineas.
Guineas are 21 shillings, 20 shillings making up a pound, and certainly not when I started in law, but that used to be the traditional way the barristers would charge as well, by the guineas.
So your mum goes to Melbourne University, studies law in the mid-1945 through, I guess, until about 1949 or 50 or something.
Yes.
Did she then go on and practice law?
No. So she met my father near the end of her law degree, and she had my sister, I think it was about 10 months after they got married. I think she'd taken the advice of someone, other students saying evidence or something was easy. She failed that subject and so was very determined to finish her degree and, in fact, sat the exams when she was pregnant. What she always told us, though, was that law was very boring and no one should do it.
Did she do articles and get admitted?
No, she never aimed to practice, and it was only when I started primary school that she decided that she should be a teacher, and she started teaching the same day I started primary school. So I was a very unusual child in the fact that I was taken to my first day of school by my father, and I still remember him standing with his hat on, towering over everybody else.
And what about your dad? What career did he pursue?
So he was basically a sales representative, but for the last 15 years of his work, he worked as a fundraiser for the Freedom from Hunger campaign.
So your school days, you go to Mentone Girls Grammar on Beach Road there in Mentone. Yes. You didn't do humanities, you're actually more a maths and science student.
Yes.
How did you get to law?
I'm not quite sure. I didn't do so well in maths and science in my final year, and I enrolled in arts, which was where my interest lay. And it was only as I went through first year that I started to decide that I needed to do something else, and that my mother's advice of law is boring may be wrong. And so I transferred quite easily at that stage. I know it's much harder now to transfer from arts to arts law, but that's what I did at the end of first year.
You go smoothly through your law degree, and when you finish your law degree, you've got to get articles and do a year's articles before being admitted.
Yes.
Was that easy to get articles?
No. I was told by one principal who interviewed me after I spoke to him on the telephone, but he told me that women can't do debt collecting, and also they don't get on with their secretaries. And so I spent quite a lot of my early years doing debt collecting, and I think getting on quite well with the secretaries. But of course, he didn't employ me. I haven't forgiven the fact that he employed a very edgy fella who wore yellow clogs to university.
It's a long time ago, Debra. I think we can forgive him now, because he was a creature of his times, I guess.
Yes.
So where did you get articles, and how did you get articles? Because it wasn't easy, because you had no contacts in the law.
No. I don't actually remember, in the sense that I was too late to enrol at Leo Cusson by the time I realised that I wasn't getting articles. And then somehow, and I don't remember how, I was advised that Doyle and Kerr were looking for an article clerk, and it was after the interview that I was offered the articles position.
And Doyle and Kerr were a small city firm and basically a general firm doing most of or a bit of everything.
They were a firm which the older brothers of the partners were in the Geelong office, which was sort of the head office, and at that stage they also had a related office in Terang. The Doyle and Kerr City office was primarily doing conveyancing for a lot of long-standing family clients, and Michael Dolan and I were the litigation team doing everything that walked through the door, including personal injuries, family law, motor car accidents, crime, whatever came.
And you were articled to Michael Dolan?
Yes.
And something that wasn't that uncommon at the time, you actually had a desk in Michael's office.
Yes.
And you were therefore hearing everything he did and seeing.
Yes, because the previous article clerk was taking my soon-to-become office. So I spent 3 or 4 weeks in Michael's office, which was invaluable. And I still don't know if the reason we got on so well was that I accepted everything I learnt from him or that we really did just think similarly.
2 people sharing an office and the phone going all the time. Was it easy to work or were you distracted all the time?
As an article clerk in those days, you weren't expected to actually do a lot. And so I spent a lot of time listening to him. I certainly didn't have a phone. At that stage, I didn't even have a dictaphone.
And all of your articles' work was doing litigation?
Yes. They offered me to do conveyancing, but I had no interest in it. And so I stayed in the litigation area.
Debra, after several years with Doyle and Kerr, you moved to the State Electricity Commission of Victoria. Two questions out of that. One, why did you move? But maybe firstly, explain who the State Electricity Commission were, because they haven't been in existence now for several decades, since the Kennett years, I guess.
Yes.
So maybe explain who the SEC was.
Sure. In between Doyle and Kerr and the SEC, I went to Hall and Wilcox. And that was my first experience of a large firm where they had 6 partners and they were acting for insurance companies. And I was, again, doing sort of their family law, some of their direct clients and some insurance work, which taught me a lot about defendants' insurance work. And then, again, I saw an ad in the paper for a position at the SEC, which at that stage had 23,000 employees because they were running the power stations in the Latrobe Valley. They were providing electricity to everybody in the state and had offices all around the state. And it was a litigation position which I thought would be interesting and may give me opportunities to, say, move into industrial relations or something like that.
And they were a statutory authority?
They were a statutory authority. They still exist. Well, the last election, the Premier Daniel Andrews recreated the State Electricity Commission, but my understanding is that it hasn't actually disappeared because it's still doing asbestos claims.
Of course. So why did you make a move to a state government authority?
I was accused of selling out, but I thought it would give me opportunities that I just couldn't get in private practice, that I'd never really been interested in pursuing partnership. I didn't see that as attractive. I preferred to do the law, and so management also wasn't really a goal for me, and I just thought that there were the opportunities to do other things if I wanted to.
So you worked in a small firm in Doyle and Kerr, probably a medium-sized firm, Hall and Wilcox, to then go into a large public service organisation. Was it a culture shock? Was it difficult to adjust?
Well, it was and it wasn't, because the legal division were only 6 lawyers and 4 support staff. So I was still in a very small organisation, really. A lot of the time you could throw a tantrum or whatever and they would say, that's just the lawyers misbehaving. It worked well.
And so what did you do there? What was your role at the SEC?
So I conducted the defendants' work in things like the general personal injuries, the old workers' compensation prior to the accident compensation scheme, also debt collecting for people stealing electricity, running into the power poles, those sorts of things, so doing prosecutions as well.
And you were doing it independently? You weren't using a firm of solicitors, or
no.
Were you using barristers, briefing barristers direct?
Yes, we were briefing barristers. I remember one, because I was instructing all the time, and the policy within our group was that we would instruct on every case, whether it was at Wangaratta, Bendigo or down the Latrobe Valley. And so I know one year I spent 16 weeks down the Latrobe Valley, because that's where most of our cases were, because our people getting injured were primarily working in the open cut mine.
Okay, and so you were, a Supreme Court personal injuries action, you were instructing?
Yes.
I assumed that actually that sort of work would have been instructed out to a solicitor, but I didn't realise you were doing it direct.
No, we were doing it all direct.
Mid-80s, you do a graduate diploma in Labour and Management Relations. Was this because you'd hoped to work in that area?
Yes, that had been one of my plans, but I enjoyed doing the litigation at the SEC, and so I just thought I couldn't rest on my laurels of the ordinary degrees, and so did that as something to challenge me.
And while at the SEC, you crossed paths with Michael Dolan again?
Yes, so the senior litigator left and I encouraged Michael to apply, and also may have explained to him the sort of interviews you get in the public service or the statutory authorities, because it's not like interviews you get in private firms.
And Michael was appointed, and then you worked with Michael again?
Yes.
Friendships help. It's who you know in this life means a lot, doesn't it?
Yes. Well, he was a pleasure to work with. So.
And then you move again in 1990. How long had you been in the SEC then? Maybe 7 years?
Yes. I was told by the secretary to the SEC, who was our boss, that no promotion would be available to me. It wasn't a reflection of my work, but just that they were trying to reduce positions, staffing numbers, etc. And so I looked around and found the position, which sounded very interesting, at the Department of Labour.
So again, a state government department. What was your role there?
So I was the solicitor to the Department of Labour, which at that stage was in charge of the Occupational Health and Safety Authority, which was a lot smaller than it is now, and also the general litigation done by Department of Labour inspectors, so which was shop trading hours and pay conditions and that sort of thing, and then general advice, legal work that any large organisation has.
And what about Parliamentary Council? You interacted with the Parliamentary Council. How did that come about? And where does the Parliamentary Council, he or she, sit in the overall scheme of things?
So Parliamentary Council's a separate organisation. I'd first dealt with them at the SEC because to introduce regulations, the organisation introducing them drafts up the regulations, but it's Parliamentary Council who actually approves it. In the sense of legislation, that's Acts of Parliament, Parliamentary Council actually drafts it with instructions from the organisation trying to say what they want.
When you say the organisation, that's the ministry concerned?
Yes, but in the SEC, it was when the SEC were doing all their ratings. So ratings on fridges, ratings on washing machines.
This is energy ratings?
Yes, that's all done through regulations which expire after 10 years, and I was the person who got them through Parliamentary Council in those days.
So you've moved away from litigation there?
Oh, well, it's just part of the work you do in a large organisation. You have to be flexible.
Lives in the Law is proudly sponsored by City Maps Illustrated. Their recent publication, The Melbourne Map, is a celebration of our wonderful city. This stunning, hand-drawn illustration, which took more than 3 years to create, is available as an art print, jigsaw puzzle and calendar. The perfect acquisition for your home, office or corporate gifting.
Debra, in the early 1990s, there was a significant fire at Coot Island where flammable liquids and materials were stored, and Coot Island's at the top of Port Phillip Bay.
Yeah.
And that led to proposals being made to move those chemicals and flammable liquids and flammable materials further down the bay, away from metropolitan Melbourne.
Yes.
And you became involved in that through your role as Solicitor to the Department of Labour.
Yes, so following the fire, a team was created, a project team, to work out what was the best options, and I provided regular legal advice on interpretation of legislation and that sort of thing. The actual 5-week hearing was planned to be conducted just by that project team, and I suggested that they may need a lawyer to appear at the tribunal hearing, and they said not. On the afternoon of the first day of the hearing, I was called in by the department head and told that they wanted me to go down and run the hearing for the department.
So go where, Deborah?
Oh, sorry. We were sitting at Geelong and it moved several times. It was at the Arts Centre for a couple of weeks and it was at other places. So it was a fairly big inquiry because obviously there were local environmental groups concerned about the wetlands. There was Cheetham Salts concerned about the impact on their salts and what compensation they could have. Vic Roads was an interested party because of the concerns about using the roads for greater transport of chemicals and that sort of thing. So I jumped in the car and went down and did the 5 weeks.
Well, you will. I mean, preparation is everything to a barrister, as far as I understand it, or an advocate.
Yes.
Did you have an opportunity to prepare thoroughly?
Well, no. I had a good understanding of the basic issues because I'd been providing advice. I didn't have an understanding of how the case was running. And, of course, we also had experts to be called, experts from Cheetham Salts as well as from that we were calling. And so I was very fortunate that I did have time to prep the expert who gave, or the expert the department was calling, who gave me good cross-examination material for the Cheetham Salt expert. But otherwise, it was trying to anticipate what was going to be asked each day and working it through.
So this was great preparation for the next step in your career.
Yes.
Which is coming to the bar.
That's right. In my day, it was much easier to do court appearances the way things were structured, in the sense that call-overs were done by the young lawyers in a way that directions hearings are sort of done now, but there weren't. When I was young, there were many more of them. I had always wanted to go to the bar, but I'd been reluctant because I knew I didn't have contacts. So this was a great opportunity to give me a taste of what it was really like, though I had also appeared in inquests for the SEC and inquests for the department. So I've consistently done litigation, but it's a much bigger step to be self-employed and not having regular working hours and needing to be self-reliant.
And does that create a feeling of insecurity? Coming from a background like the public service where things are very structured, when you come to the bar, there's no structure, it's all up to you. Does it create insecurity?
Well, I was older than the average and I felt that I had enough behind me financially, so it didn't create insecurity. I enjoyed the freedom of being able to do a case and then if the case finished at 12 o'clock, you were done for the day and you didn't have to go and do more work, presuming that you didn't have a case on the next day that you had to prepare.
So this is 1997 from memory.
Yes.
Were you busy from the start because of the background you had both in private practice and in the government?
I was, because there was some dispute in the personal injury bar at that time. And so I was given work that I probably wouldn't have been given on my level of experience at the bar if it wasn't that the more senior members were refusing work until, I assume it was over fees, were sorted out. And that took about 6 months, I think. That sort of introduced me in. So I started off doing defendants' work, but then moved to doing plaintiffs' personal injuries.
And who did you read with?
I read with Michael Croyle, who was a barrister that we used to brief at Doyle and Kerr, and he worked in workers' compensation. He'd been a member of the Accident Compensation Tribunal and later joined the Financial Industry Ombudsman.
So, Deborah, in coming to the bar then in 97, and your practice is a personal injuries practice, originally defendant and then plaintiff.
Yes.
Did you enjoy the work? Was it a busy practice?
Yes, I enjoyed the work because I'd always been doing personal injuries really as sort of 2/3 at least of what I was doing. apart from the time in the Department of Labor where I still did some, but not directly. And I did have one experience which was interesting in hindsight, and that was that I appeared in the Magistrates Court on a workers' compensation claim, where I said to the plaintiff that I didn't understand how he had the work incident and I didn't understand his work history. So,
is this your client or the other side?
This is my client. And so I said to him, because I haven't understood it, I've adjourned the case so that your solicitors can get some more information and work the case up. I didn't receive another brief regarding that fella. And when I got to my later job at Corrections, I discovered the reason I didn't understand his work history was because he was a gangland contract killer and he didn't have a work history because he was in prison quite a lot, and the solicitors had discovered more about him and got rid of him as a client.
The interesting things that happen in the life of a barrister, Deborah.
Yes.
William and Lonsdale is brought to you by Green's List, one of the leading multidisciplinary barristers lists in Australia. Green's List believe in promoting conversation around the ideas and issues that shape not only our legal system, but our wider community.
Well, now you've mentioned Corrections Victoria. Why did you move there? You're at the bar, you had a busy practice and an enjoyable practice. Why did you decide to go to Corrections Victoria?
I think it was that I had a bit of a hankering for the regular pay. Not that I was doing okay, and in fact took a drop in sort of my notional income to take the position. But I thought it was going to be a very interesting job, which it turned out to be. And I always had the thought, which was very strong in the first couple of months, of I can always return to the bar if things get too grim here, because some of the things were a shock, as I'd forgotten what being in the confines of the public service was about, the controlling issues, the fact that people within the organisation can make decisions, but some of them are still made politically and may be made higher up the line, so that there's an agreed position as to what's the sensible outcome, but that doesn't work.
That's an interesting point to get back to, but can I just get you to give me the structure? Corrections Victoria, I assume, came into existence at the time when the prisons were privatised. So we've got privatised prisons. The department used to be the Attorney General's department, I think, that was in charge of these things. What was the structure? How did the whole system fit together?
So there are only 3 private prisons, and there are, I think it's 12 government prisons. So it's still a government structure. The Commissioner for Corrections, who's a senior head within the Department of Justice, has the power to control both public and private prisons under the Corrections Act. He or she, the last 2 commissioners have been women, runs the public prisons in the form really of the public service system where everyone is public service employees, and directs the private prisons as to how to run. Because of the various issues that have occurred there, I used to have quite a lot of dealings with Port Phillip Prison simply because it was a big prison with a lot of issues arising because it's often dealing with new prisoners recently brought into the system, and that's often where it's most difficult.
And Port Phillip's a private prison?
Port Phillip is a private prison.
Which other prisons are private?
Ravenhall, which is near Port Phillip, and Fulham.
Ravenhall and Fulham, have they got any particular function they serve? Are they for women prisoners, male prisoners, sex offenders, whatever, or are they just a general prison?
I have to tell you that there are only 2 women's prisons, which is a reflection on the male population. And all the rest are male prisons, so they have a lot more options as to how they can house them and things. So Fulham Prison is a medium security prison out from Sale, and Ravenhall is a new prison which has aimed to provide more in programs to prisoners. Port Phillip is a through prison that's often used simply because of the structure of the system as people being moved in and out through different prisons are housed at Port Phillip as they move from one prison to another.
In terms of outcomes, in terms of fulfilling a role for the community, is there any difference between private prisons and public prisons?
No.
They are equally as good or bad as each other?
Yes. Some prisoners will say Port Phillip is bad, others will say it's good.
In joining Corrections Victoria or taking on that job, what was the job? What was your role?
So there were 3 of us in the legal team at that stage.
For the whole of Corrections Victoria?
Yes. So, but we also used external lawyers, the Victorian Government solicitor and external lawyers. One lawyer just did legislation. One lawyer, the manager, did the new sex offenders monitoring work.
Sex offenders monitoring work. This is to do with
the serious
things on your ankle or whatever, bracelets on you.
Yes, the serious sex offenders work. So when it was first established, she was told that there'd be about 3 applications a year, but it turned out to be many more than that. And there is now a big unit within corrections whose work it is not just to monitor them, but to do all the programs and work surrounding it. And I did all the other litigation that arose, which included personal injuries claims by prisoners because they're not covered by any scheme other than the common law, which means that there's tripping, slipping, assault, things that occur in prisons. All of those have potential claims, as well as administrative law claims, so that if a prisoner is punished under the Corrections Act in a tribunal hearing run by a prison officer, a senior prison officer, they have a right to review to the Supreme Court.
And were you in the Supreme Court very often? Were people regularly making claims?
There were some regular litigants who obviously, if they'd used their brains for good rather than evil, would have been better for the community and our legal team.
Would you care to name some of those regular litigants?
Well, they appear in the court lists of cases, Julian Knight being one, Hugo Rich another, and Craig Minogue.
Let's go back to Julian Knight. What was Julian Knight in prison for?
He was the Hoddle Street murderer who killed 7 people and injured 14 others, I think it is.
Shooting people who were driving down Hoddle Street.
That's correct, yes.
And one would think that he was in prison for a good reason and wouldn't have much sympathy for him, and yet he was a regular litigant. Yes,
because he was able to either review decisions made by the prison officer tribunal where the penalty, the maximum penalty is 1 penalty unit, which originally was $100. It's now about $190, I think. And they could then challenge that decision in the Supreme Court. He also raised issues about various conditions that he thought should be challenged. And again, that was an application to the Supreme Court.
He did these himself? He didn't instruct a solicitor?
No, he did those himself.
Was he competent?
He certainly learnt things along the way and became better, but there is a difference between doing your own case and doing one that you have proper legal advice on, which narrows the issues and also a lawyer knows more about what to focus on and whether the particular argument is worthwhile.
May he have been happy to take a shotgun approach where he didn't narrow the argument and kept it as broad as and touched every issue, whether relevant or irrelevant, simply to drag things out?
Certainly, I think most prisoners like time out of prison, where they're called Mr. So-and-so and treated in a nice way by very polite judges who may not have treated them so nicely when they were being sentenced. But there's also the downsides in going to court and running your own arguments. But those 3 prisoners were comfortable doing it, it seemed to me.
Another serial litigant you mentioned, Debra, Hugo Rich has also been mentioned in our podcast by the policeman who was investigating his case, named Dave McGowan. As I remember it, Hugo Rich was in jail for having killed a security guard after a bank hold-up. He was regularly in court, and maybe still is, arguing his own cases. And I seem to remember people telling me that he was a bright, intelligent person who could make a decent argument.
Yes, well, I think he may have gone off, or he just hasn't found what he was always looking for, which was the big argument for the High Court. Because under his previous name of Olaf Dietrich, he was the person who persuaded the High Court that a person charged with a very serious offence should be given legal aid, and really changed how legal aid operated in that position.
Did he argue the case himself before the High Court?
Yes.
Sitting here in Melbourne or in Canberra?
I don't know. That's before my time, and it's a long time since I've read that case. But he says, the judges said he was better than some counsel. I've heard him a lot, and to me he proves that you shouldn't act for yourself, because he gets distracted by what he thinks are the important points without sort of knowing where the important points are.
And what about Craig Minogue? You mentioned Craig Minogue.
He's the Russell Street bomber. He has also challenged corrections on some of the policies and some of the principles of things.
I must say you've come across some very high-profile cases, one being the Ben Breaker case, which was, the first terrorist case?
It was the first terrorist case in Victoria. There was one in New South Wales running at the same time. The corrections staff were very upset because in New South Wales, prisoners going to court had a helicopter escorting them, and the corrections guys in Victoria only were in vehicles with a dog and a rifle.
And so how did Corrections Victoria become involved in the Ben Breaker case? One
of the big issues in the Ben Breaker case was, and it was a continuing issue, and again there's many reports on it where Justice Bongiorno was asked to rule, were the conditions that the prisoners were held in and the conditions that they had in court. The usual rule is one custody officer in the county court and 2 officers in the Supreme Court. Because there were 11, I think, alleged terrorists, that meant that there would be at least 22 officers in the court to manage them, and Justice Bongiorno found that too big a number.
You then no ongoing involvement?
I was regularly called to court, and I went to other courts as well to discuss prison issues. Sometimes it was comparatively simple things like complaints that the prisoner was falling asleep in court. I didn't like to say that the prisoner is not as riveted as all us lawyers, but I'm sure that there was an element of that. And also, of course, prisoners are not used to sitting in court all day. It is a struggle for them, particularly if argument is more about sort of legal technicalities than what they actually did.
In going to courts and discussing issues regarding prisoners, did you actually get in the box and give evidence? Or?
No, I gave it from the bar table. It was evidence, though, and I had all the governors of the prisons on speed dial so that I could speak to them and get instructions about certain matters, because it was seen as my time was much better spent in court than calling in prison governors. So that's what happened.
Now, what about prisoners complaining about being touched by women? I would have thought most prisoners would be happy to be touched by women.
No, that was during the Ben Breaker trial. They were under a high security escort, which had a few women as well as men in the high security escort.
And so these are the people accused of being terrorists?
Yes, and so their complaint was that as Muslims they shouldn't be touched by women, which happened when handcuffs were put on them. And I was called up and I said, we're an equal opportunity employer. And Justice Bongiorno took it no further, which I think was probably about the only time I actually won one of our arguments as to why the conditions were appropriate or inappropriate.
It sounds to me like your 17 years at Corrections Victoria was really interesting and raised many interesting legal points and interesting human points as well, because despite the fact they're prisoners, they are human beings and have got...
Yes.
Despite all that interest, personally, humanly, legally, you come back to the bar?
Yes.
Why?
Well, I'm afraid I'm a bit old now.
You're not as old as me, Deborah.
And so it was, for me, a retirement package. It was open to everyone over 50.
This is at Corrections Victoria.
Oh, no, through the public service generally. So I decided to take it because it's not as easy appearing for corrections when you're not actually in corrections. And I was getting more remote from my knowledge of corrections, and the burden was sort of quite heavy. I took the package and then I decided, what do I want to do next? I decided I wasn't ready to retire. I thought I could still contribute and my brain was still working. And so that's why I decided to come to the bar. And that took quite a bit of effort, where friends and relatives said I was mad, because I did sit the bar reader's exam.
Why was that? I mean, someone with the experience that you've had over, stretching back to the 1980s, in court, in and out of courts all the time for the last 17 years at Corrections Victoria, why did you have to take an exam? Well,
that's the decision of the bar readers course, the entry or bar council. I'm not quite sure who made the decision. If you are a member of the bar, you can automatically re-sign the bar roll if you do it within 10 years. I was well aware of the 10-year rule, and because I was 17, I gave them my CV, of course, and this was their requirement. So I had to sit the bar reader's exam, not in the 3 hours that ordinary people do. It was done as a take-home exam for 5 days. I also had to do a couple of compulsory subjects. Again, discrimination.
Which subjects? Eh?
Discrimination and sexual harassment. Having worked for the Department of Labor and been quite active in the Equal Opportunity Act, ours at the SEC was one of the first discrimination cases in the Equal Opportunity Commission. And of course, in the public service, you do get training on these subjects, but the bar still wanted me to do it. So I attended those classes as required, and I also had to read with a mentor for 4 months.
Surprising.
Yes, well, I was surprised. I did it as painlessly as possible. Once I did all that, I was able to re-sign the bar roll, and they don't check up on you after that.
So in this second stint at the bar, what areas are you practising in?
What I thought I would practice in, because I didn't really want to do the heavy slog of personal injuries, I thought I'd practice in what is called by the Law Institute elder law, that is working with people or their elderly relatives in cases at VCAT, disputes about not so much inheritance, but how people who may be deteriorating, how their money is spent on them and for them. And I also thought I could do some pro bono work, and I've done some of both. The pro bono work has been for prisoners who are not prisoners that I know, but are prisoners who haven't been picked up by other people, because I think that they're a bit nervous of dealing with prisoners. I'm happy to do that, and more recently, I've been doing quite a bit of work for the Office of Public Prosecutions, because I can probably say that I know more about community corrections orders than most people in the state. And I've also been responding to bail applications and other small matters.
So you're away from the bar for 17 years. You've now been back 2 years, roughly.
Yes.
Has the bar changed? I mean, COVID, of course, I assume made a huge change, but I'm interested from your perspective. And what are the changes, of course, if there are changes?
Well, you've moved on. Apart from that, I'm shocked at how old some of the people look to me. It's still the same people walking around the building, it seems, but a lot of them look a bit frail.
17 years will do that to you, Deborah.
The biggest change is that barristers aren't in chambers all the time, and they dress more casually. And I think that is COVID.
The way the system works between solicitors and barristers, that's still the same?
Yeah, except getting electronic briefs will do your head in.
Debra, you better tell us a bit more about elder law. We hear horrific stories about older people being discriminated against, used up by their own families to get at the assets and money of the older people. Is it happening a lot? And is that, am I understanding that's what elder law is really about?
Well, I did some of it when I was last at the bar, where people were going in and out of a good mental state and that sort of thing, and families were trying to support them. But the cases I've had recently, one was where a woman is going in and out of a mental state and is heading towards dementia. She was a successful businesswoman, has quite a bit of money, has given quite a bit of money over the years to her family. There's been pushes by the children as to what they now see as their inheritance just dangling before their eyes. And so I was acting for the person who had the power of attorney, while the other members of the family were seeking for her to reinvest the money rather than in the bank term deposit stocks that the mother had always used. The emails from the siblings were saying things like, it's our money and cryptocurrency would make a much better return than bank deposit stocks.
That's pretty ugly stuff. Is it becoming more commonplace?
I think so. I keep reading in the paper about the baby boomers soon going to leave money to their children, but it's more about the expectations of what people who may not have been as successful as their parents are wanting to do and how they perceive they can get benefits. And in that particular case, there was very clear guidance from the past conduct of the mother and her investment strategy as to how she expected things to happen.
And was this before VCAT?
This was before VCAT as a preliminary case, and I was confident that once I mentioned investing in cryptocurrency as being a strategy being considered by the complaining other children, that VCAT would have a similar reaction to me, which was that they thought continuing with bank term deposits was a good idea.
Debra, as we sit here today and we start back with Doyle and Kerr and work our way through the SEC, the Department of Labor, the bar again, Corrections Victoria, would you change anything?
I don't think I would. Of course, there were decisions along the way, and sometimes decisions were being made for me rather than me making them. But I've enjoyed my time. As I said, I wasn't ambitious to be a partner. Apart from, I always thought that if I did become a partner, I would have pink lights in the ladies' toilets so that I didn't look so bad at the end of the day. That was my only real ambition. I didn't really have the ambition to be a judge. Now I know so much more about prisons. I don't know that I could ever send anyone to prison. I'm more than comfortable with people being in prison, but I just think that's not for me, being a judge. And so what I really like to do is representing people, and that's what I've been doing really all my life. With working in the statutory authorities and the government, I'm normally working for an intelligent client, and that's good, but I also like working with real people too.
And you've had the opportunity to do both?
Yes.
Debra, thank you for coming in this morning and telling us about your unique career. I know of nobody else who's had a career like yours.
I thought it was pretty ordinary myself.
Well, I think it's, in fact, I'm sure it's unique. And I found it fascinating to hear about it. Thank you very much.
Thank you.
Show notes from today's episode can be found at greenslist.com.au/podcast. There you'll find links to things we've talked about in this episode, a transcript of the show, and some wonderful photos of our guests. If you're enjoying Lives in the Law, please tell your networks, subscribe, rate and review the show. Your host is former lawyer and Greens List clerk Michael Green. Our show is produced and edited by me, Catherine Green, mixed and mastered by Windmill Audio, and recorded by Alex McFarlane, who also wrote and performed all the music for the series. We're coming to you from the iconic Owen Dixon Chambers on the corner of William and Lonsdale Streets in our beautiful city of Melbourne. We acknowledge the Wurundjeri people of the Kulin Nation as the traditional custodians of this land and pay our respect to their elders past and present. There is no doubt that conversations about justice have been taking place on this land for thousands of years, and we are privileged to continue that discussion here today.